The following are a few excerpts from a conversation with some of the specialists that work with members of the Law Club as it relates to stopping foreclosure, uncovering bank fraud, and related issues. So, hope you enjoy it.
We do a full fraud and robo-signing analysis. We do a credit default swap analysis, as well as a chain of title analysis of all the assignments and transfers showing where the loan went from origination to now. Most importantly, it comes with a courtroom-ready expert witness affidavit from Michael Kerrigan. I'll give you an overview of Michael. He's the nation's leading securitization expert witness and has testified in more than 15 different jurisdictions. He's our senior instructor for CFLA's nationally recognized and Department of Education approved mortgage securitization analyst certification course. He's trained and certified over 500 industry professionals in the forensic loan auditing industry. He's also performed over 3,000 mortgage securitization audits. And I'll give you his background and licenses. He's got an MBA in finance, a BA in accounting. He's a chartered financial analyst, Series 7 and Series 63 securities license. So you're not going to have any problem getting him on the stand, okay?
So he comes on as an expert witness, huh?
Yeah, oh, absolutely. He's phenomenal. Yeah. Our litigation package is a full petition for equitable relief and special damages, listing up to 12 to 15 different causes of action, all based on the findings of the audit report. It's a 40-page full turnkey lawsuit to sue your lender. It's jurisdiction specific. It's specific law. It's audit specific. Everything that the client's going to need is a turnkey deal. Now that complaint also comes with if they need it, we send with it a motion for a temporary restraining order to stop the sale if they have an imminent sale date, and it comes with a list pendants to cloud the marketability of the title. So it's the most comprehensive package in the industry.
Wow, sounds like it. Yeah. And how do you handle geographic issues, or is most of this done by paperwork?
Most of it's done by paperwork. Yeah, that's no problem. We can mail, affidavits if need be to, for clients, the originals and things of that nature if they request that.
So your expert witnesses would be used in the event of an actual courtroom proceeding, and the ideal situation is it doesn't get to that point, huh?
A lot of cases settle out. Yes, sir. Yes, sir. I'm sorry?
I was going to say I hope so in the forensic audit process. It's my understanding that most of these banks and lenders are operating outside the scope of the law, ultra vires, and so you should be able to expose that maybe in the audit process, no?
Yeah, it's definitely an accommodation, table-funded transaction. We understand the mechanics of that transaction 100%. Absolutely.
Mm-hmm. Okay. So the quiet title package, and then break it down for me on, you said the forensic audit, that's a separate arrangement?
Yeah, yes, sir. It comes with two packages. So for the Bloomberg Securitization Audit Expert Witness Affidavit and all the assimilated exhibits to get into court record. And then if the client wants to take the next step and have one of our staff attorneys create the litigation package.
Is it a hope that they don't have to get to a litigation stage with the first securitization audit?
It depends on what the clients, what they're in for. Some people, their prerogative is they want to, set case law in their state and want a free and clear title, and they're willing and they understand, they have the wherewithal as to what that really means to prepare for trial, discovery, depositions, expert witnesses. Some people don't really know what that means, So some people have the capacity to understand that, and absolutely. Some people are looking for the same posture, right? Filing an action and hopefully, pretrial motion settling prior to having to go to that type of situation. But we're going to make sure and hit them with the biggest stick that we can coming in the door, for sure.
Just talking with Frank, it's kind of a crapshoot these days with the courts. You never know, how they're going to rule. They don't follow the law. It's only when it's convenient for them. So,
well, if you make an admission to an indebtedness contract, it's a pretty good chance you're going to get beat. But as long as you have the proper facts and you can make the proper arguments, you have the proper evidence, and you have the proper expert to come to trial on your behalf, those are the resources that we have the capacity to provide within the scope of the rules of civil procedure for each jurisdiction.
Okay.
again, what Damien's doing is he was an underwriter for the banks for the secondary market, actually creating these mortgage-backed securities before he became a licensed private investigator. That was his background in the mortgage industry. So he's very familiar with that transaction, these table-funded transactions, and how that works. And working with one of his mentors, Professor Levington from Georgetown University, they spearheaded this new complaint that we're about to unroll nationwide, which we're very excited about because statutorily it's airtight, right? I mean, it's not going to be a slam dunk, but it's basically the strongest thing we have as far as a foreclosure defense is this argument that the homeowner signed the note as an accommodation party. So there's like if they would have co-signed for somebody to buy a car, the title of the car is not in their name, the financing obligation is not in their name, they're just on there as a guarantor. That's basically what happened with the securitized transactions is, the pretender lender, the person not listed on the note, they were just the broker or the originator. They never put up any money on the transaction. The money came from a banker who's not even listed on the note. So that's really the heart of the argument today, 2016, as opposed to all these other things we've been using for the last 5 or 6 years. Show me the note and the robo signing and all of that basically doesn't really get a lot of traction anymore in court. This is the next generation of argument.
Okay.
Which is the only argument. It's statutorily airtight. Again, it's been scrubbed by top professors of law, and it's been given a green light. So we're pretty excited to start implementing that into the work product there at CFLA.
Yeah, if you can base it on a pure statutory argument, you don't need to get into all these side issues.
The bottom line is, this mortgage loan contract is not an indebtedness contract, period. So there were never any rights over the collateral were ever created statutorily. And that's all under Uniform Commercial Code. So, that's one of the difficulties is now getting the attorneys to understand the argument and then argue it properly, let alone the homeowners. I don't think the pro se's are going to be able to do it, so we're recommending a blend. We're recommending that the people, if they have to, start the process pro se and then bring in the right attorney in a limited capacity. But what we do that's different is we're very big on the education course, Jurisdictionary, which teaches people how to contract and control the attorneys. How do you control the judge? How do you control the bank's attorney? All of that can be learned to where the pro se, who's educated, working with an attorney that gets it, the light bulb's turned on. That's a powerful combination.
Yeah.
Yeah, but I mean, again, it's not a silver bullet. I don't think there is one, but we still have to, stand up and fight while we can, right? So
exactly. No, that's a great concept though, because I've stood in court more than once, a couple times facing felony charges on my own, and I prevailed on more times than not. And while I certainly wouldn't accept an attorney to represent me, having one to guide in terms of procedure and staying on point with the right arguments, that would surely be immensely valuable.